Today is Monday, the 11th day of November 2024. I am George Wenner, and I am here on the steps virtually of the High Court of Justice with the claimant, Mr. Alister Thomas, who brought a matter against the Antigua and Barbuda Electoral Commission. This morning, Judge Jan Drysdale delivered her decision, and Judge Drysdale ruled in favor of the respondents, that is, the Antigua and Barbuda Electoral Commission. They prevailed in this matter. And I have with me Mr. Thomas. What are your thoughts on what we just heard in the chambers of the High Court, Courtroom 3 just now? What is your take on this whole matter?
I'm a little flabbergasted. As the learned judge read her rulings, it left me to wonder if I was hearing what I was hearing. It leaves me now to ponder and to seek the resources to go beyond. I'm not satisfied. I'm not satisfied of the judgment and the arguments in relation to the ruling, because I still contend there is no aspect of the registration of voters that can be confidential. And if the names are not confidential, and there's no need to protect them because you can have them 365 days a year if you need to, the register that is. But if you attach a picture to it, then it becomes dangerous or risky. I do not understand that reasoning, because the name of the registered voter is listed in the book and in the specific constituency. So if you had any ulterior motive or intention other than something that you would say normal, all you need to do is go to the constituency and inquire who the person is, and you will find the person if they're here. But to suggest, my understanding is that there is some extra risk, or there's some risk that the individual who is a registered voter, because there's a picture attached to the name, that need to be protected. I do not understand. I'm at a loss. So
that's an important point you just posited, in that the register is published and distributed widely across the various constituencies in public places, supermarkets, and it's made available, and it includes not only the name of the elector, but the address, the profession, and the sex of the individual, and you're just asking for the said picture list that is used on the day. And the judge is ruling that to include a picture of the individual undermines the safety and the security of the said individual, when in fact persons who present themselves to be an elector in a particular constituency go through a process of claims and objections, where those persons can go and see if the person truly reside where they say they reside, and challenge the authenticity of them being on the list. So what's the difference?
Absolutely.
A photograph.
So that's why, as I sat there and listened to the learned judge read her summary and her judgment, I was at a loss. To me, there seemed to be a contradiction that the non-picture lists can be available as a public document at all times, but the one with the same names with a picture attached, there is some risk to it. I know. I am prepared to go beyond, and I do hope I can get the public support as far as resources, and while I get it, I'll go beyond. I need to hear another court decide that.
So we're looking for you on the steps of the appeals court.
That's my intention. All I ask the public to do, give me the support, and let's carry this to logical conclusion, because what we need is transparency and the confidence of the public. For me now, what I'm hearing here makes me very much concerned that something is amiss.
There you have it, folks. George Wenner holding their feet to the fire, keeping them honest.